Hello and wonderful day to all of our friends around the globe. My name is Mary, and I'm so happy to be joining you once again right here at Silmi Law's Immigration Conversation. And of course, we have the one and only, the best attorney, Attorney Sharif Silmi. Hi, Sharif.
Hi, Mary. How are you? Thank you for joining us in allergy season. I know I'm suffering, so
I know.
with everything happening with the pollen and all that, but we're going to try to brave through this. I think you're also having, the same experience. So, but there's a lot of good information that we want to share with folks out there and let them know what's going on. So, hopefully it's a wonderful opportunity.
For everyone. Yes. So I'll start ahead, Sharif. So basically, many of our friends and those who consulted with us, they want to know, election talks and everything. How important is it to file their case right now? Many of them. Somebody I just spoke on the phone a while ago after he consulted with you last week. He was like, "Can Sharif finish my case in like 4 months, 5 months, six? Like less than 6 months." So what's your take on that, Sharif?
Oh, it's absolutely very important. I mean, I think that while for the most part, I'm always sort of inclined to think about, the statutory requirements that exist under the EB1A petition in particular, as well as any other petition. I think that there is a really, significant difference in how, the current administration is instructing through its Department of Homeland Security and eventually USCIS, the adjudicators as it relates to reviewing of petitions and such. And we have seen, just the unbelievably, successful phase here at Silmi Law as it relates to, those approvals. I mean, I think we've sort of always, been really consistent in terms of approval, even during the Trump administration. But what I have seen is even cases that I would say are borderline or maybe not as strong as others have also been able to kind of, garner approval often without an RFE in the present climate. And I think, if things go in the direction of a maybe less friendly immigration, president, that's going to kind of work its way down to the, various agencies, including USCIS, or in particular USCIS, and that's going to result in a different adjudication environment. I mean, I think probably 75 to 80% of people would not be impacted by that, but there are some cases on the margins where, there's going to be, I think, an impact.
Like maybe is it okay if we become more specific? Like in the past weeks, many of our friends from China, those who are Chinese born individuals who are working here, suddenly many of them are inquiring. A couple was even trying to rush and sign up. Do you think I mean, in terms of like especially for the Indians and the Chinese especially, what do you think is the impact on them, and how important is it to take your matter in your own hands right now before, I think, what did you say, January 20th or 15th?
Yeah, the inauguration of a new president will take place January 20th. So that's the date where, I mean, it's not like the first day of the administration there will be immediate changes, but I think that there will be a change in environment, and in particular, you'll start to see executive orders issued. So
Yeah.
usually they'll have a bunch of executive orders that they're going to put forward, and many that will be rescinded. So,
Mhm.
for example, based on some executive orders that Biden has put in place, the Department of Homeland Security has changed certain or issued policy memorandum that
Mhm.
have favored those who are working in what are described as critical and emerging technology spaces. So anyone who's working in an area of critical and emerging technology presently has some favorable outcomes as it relates to specifically national interest waiver and ONA, but by, I would say, connection or similarity, the EB1A. That
Mhm.
is why what we have done is say that anyone who comes on board to Silmi Law by May 15th, if
Mhm.
the circumstances require we are committed to making sure that their case will be submitted and presented for adjudication prior to the end of the calendar year. Often it's much faster, but I guess at the end of it, or the deadline for us would be to file it within this calendar year. Of course, that's something that's being based on an analysis of the case, and we'll tell you straight up whether we're able to do that. Often there are cases. I was privileged to be invited on a podcast. I think it was a couple days back, um, for one of my former clients who's really successful in his career now after he's gotten his EB1A approved. And his case, I recall, took a year and a half to 2 years to develop, right?
Yeah.
And that's just because of those individual circumstances. So there are cases where I'll tell you straight up, it's not going to work out within the time period that we would like. However, many cases we can make happen prior to that. Excuse me. There we go with the allergies. Prior to the end of the calendar year. So I'm very confident about that. So those of you who are out there who are saying like, look, this is your last best opportunity. Possibly this is your last best opportunity to acquire an EB1A. And once this window closes, I mean, for cases on the margins in particular, but you don't have a huge amount of evidence to go out and develop further, you need to really, put your foot on the gas here and, make sure that we're able to kind of put you in a situation where you, will be approved clearly prior to, the calendar year ending, because like I said, there could be some major changes taking place.
And since you mentioned, Sharif, about the executive orders, the way I see it, and what we've proven so far for many of our happy clients, like whenever they put out an executive order, right? Like what you mentioned, the critical and emerging technologies, we basically, as a firm, take advantage of that, right? So we position your profiles in such a way. We uniquely tailor, right, your petitions based on whatever the current administration puts out. So what basically you're saying, Sharif, right, is that we, while it's there, it's best to take advantage of it now.
Absolutely. And, honestly, there's winners and losers in every administration. I mean, I recall during the Trump administration, we had enormous success with people who are working in the energy field, right? So those who are in like oil and gas and like refining technologies and such, I mean, they were like off the charts in terms of, approval. So there will be, for example, if you think about like security related professions and such, they might start to have, like, when you think about the prospective benefit to the US, there might be some changes that would sort of, invite further acceptance of casework as it relates to areas that are of higher priority from one administration to another. The present administration, I think, rightfully has concentrated heavily on semiconductor-based technology and on just the critical and emerging technologies. So those critical and emerging technologies, I think, are of particular noteworthiness because they tend to really, I think, impact the way cases are adjudicated. So I would definitely urge people to put more emphasis on critical and emerging technologies when they are filing their cases, because if they are not discussing critical and emerging technologies, and you're out there working on your EB1A, or somebody's work on your EB1A case for you, then you're not on the right track. I mean, you're not maximizing your opportunity for success. So look, it's definitely the case that every once in a while, a case where you have, reviewed Stevie and Globee Awards and done an iJurt publication and paid media, right? One in every 100 or so, or 2 or 3 in every 100 might actually get approved. But like, you're not like going to trick anyone, guys. Like, this is not going to work. If you really want to be successful, you have to have a sort of uh, basis in reality. You have to have a qualitative approach.
Qualitative.
It's really, I mean, there are organizations out there charging huge tens of thousands of dollars, multiple, tens of thousands of dollars, and all they're doing is telling people to go, publish something in iJert and, going, I'm doing it for free right now. You don't have to pay me anything. You can go do paid media, right? You could publish in iJert and you could do Cody and Stevie Awards. There you go. 3 criteria. You're going to have a 1% chance of approval, and most likely you're going to get an NOID, right? So that's the situation. I'm not doing this to hurt your feelings. I'm doing this to help you, because the reality is, if you want to be successful in your EB1A petition, you need to base your case upon qualitative, impactful, documented evidence, what you've actually spent your life's work doing, not some BS kind of, cooked up, sort of things that you're doing in the last minute, scrambling to present a case. So a lot of people will be like, what is he talking about? But many more people are gonna be like, I know exactly what he means. And, we're going to reach out and try to get better advice than we have been getting thus far. So hopefully that will help. If I could just share my screen, I just want to remind people what critical and emerging technology list is all about.
Okay.
And then maybe also, if you have questions about the visa bulletin,
Yes.
we can do that as well. So here we go. So this is the critical and emerging technology list, right? And this is the updated version as of February 2024. It is a very, very important document as it relates to immigration. So anybody that's out there that is a high skill individual and you have not looked at the critical and emerging technologies list, you need to do so. There are, it comes out of the National Science and Technology Council, which is part of the White House. There is direct reference in various policy memorandum, basically instructing the adjudicators to reference this document while they're making decisions as it relates to various cases. It has a very high level team. There's every U.S. agency is a part of this. And when you get to the actual list, you will find that, so there's an overview. It kind of gives you some useful background information. And then when you get to the actual list, right, it will have the sort of bullet points of the areas of particular importance to the national security of the United States. And that is advanced computing, advanced engineering materials, advanced gas turbine engine technology, advanced and network sensing and signature management, advanced manufacturing, AI, biotech, clean energy generation and storage, data privacy. So this is a huge one, right? There's a lot of folks out there who are data engineers, right? So data privacy, data security, cybersecurity technologies, enormously huge opportunity to get your EB1A approved. So you need, I mean, obviously this does not negate the requirements that you have to show as it relates to demonstrating that you are, at the highest level of your field. But if we think about the statutory requirements that exist for an EB1A petition, they are that you have to prospectively benefit the U.S., bring about future benefit to the United States. Well, talking about critical and emerging technologies will help you in that regard. That you have already achieved sustained acclaim that is recognized in your specific field. This is where you could sort of find a field that makes a lot of sense for your petition that is elite enough to, merit the EB1A regulatory criteria approval. And then lastly, that you will continue to work in your field. This again is going to be very informative and helpful in that regard. So, data privacy, data security, AI, biotech. I think sort of advanced gas turbine engine technology is one that I've seen a lot of, actually. A lot of people that work for, in even the Northern Virginia market, like, a lot of the ships that they have, huge gas turbine engine technologies that are going into, carrier ships for logistics and things of that nature are there, like Rolls Royce and such. Then you have clean energy generation, storage, data privacy, directed energy, and then so you could actually see really quick where it gives sub categories or sub areas. So if we look at directed energy, for example, it'll talk about lasers, high power microwaves, beams, right? So this is a very scientific field. Highly automated, autonomous, and uncrewed systems and robotics, right? So this is sort of, talking about autonomous vehicles and such. Human machine interfaces, augmented reality, neurotechnologies. You're seeing some of that. Hypersonic, and integrated communication network technologies. So like radio frequencies, positioning, navigation, and timing technology. So there's really a lot to choose from. And then there's some that are sort of like catch-alls, like advanced computing, data. You could kind of have anybody who is in, certain segments can really benefit from this. But what's really, really important is that you are somehow using this. And I really pride myself on making sure that whatever case we're preparing in our office is really steeped in sort of policy, right? Because anybody could just, throw out whatever, criteria. Do I meet it? Do I not meet it? Kind of a vanilla case. And then, you see a lot of cases where they just have a bunch of letters and the whole, letters copy pasted. But what we like to do is try to make a policy argument that kind of tells your story in a way that combines the policy reasoning as well. And we find that, results in a very high level of approvability for our clients. So, we're very grateful and thankful for that.
Basically, it's like your strategy is boxing them in, right? Putting back the policies that they put out there. But I think, Attorney Sharif, it's also important to note, especially for our clients who are waiting to sign up right now. It's not just with this policy. I think some of them are also would like to know about your strategy, which you're known for, which is of course narrowing down their field of endeavor, which you mentioned in the past is very important. Of course, there's the list, but it doesn't mean that you qualify right away, right? Just because like you belong to a specific area that's on the list. Can you expound a bit more regarding making sure that you get to
Yeah, absolutely. And like what's interesting is like you have a subcategory of categories. So I would go even further to like make a subcategory of the subcategory, or even multiple layers to get into a very narrow area, but that you could connect back to sort of a larger one. So I always like to give myself as an example. So if I were to be thinking about an EB1A petition, I would, like obviously I could say, okay, well, in a professional sense, I am an attorney, right? So if I were to submit an EB1A, I could say, okay, well, my field is law, right? Well, that's a very broad field, right? With, hundreds of thousands, even a million or so, or possibly more attorneys. I've heard something like 400,000 law firms exist. So, presumably you have more than a million attorneys. Then so you could narrow it down and say, okay, well, instead of being in the field of, law, I'm in the field of immigration law. So just by narrowing it from law to immigration law, there are 400,000 or so law firms. There are 17,000 immigration law firms, right? Wow. So, we're talking about maybe 5% of all, so 95% of the competition has just been eliminated by saying immigration law as a field rather than law. But I would again go further. I would say, well, actually, my field is employment-based immigration law. So that is probably a third of all immigration law firms, because about a third will concentrate on humanitarian-based cases, a third on family-based cases, and a third on employment-based cases. So maybe now we're down to about 5,000 or so firms out of potentially maybe we're talking about 400,000, right? So we're about at maybe 1.2% or so of the larger number. If I just said my field was law, by just changing it to my field is employment-based immigration law, I'm among the foremost experts, not in law, but in employment-based immigration law. I've eliminated, 97.8% of the competition. And then I could even go further. I could say, well, actually, it's not really just employment-based immigration law, because I don't really do H-1B, cases and such. So actually, I'm an employment-based immigration law for self-petitioning immigrants, right? So now I'm in a very, very narrow area. There's probably only 20, 30, 40, firms or attorneys who really, have particular specialization in this area. And it's a lot easier to make an argument that I've risen to the very top of this, I would call it hyper specialized area of endeavor, right? So that is what you really want to do. And that's what I'll help you do if you are out there and not sure about how to sort of craft a winning case. That's one of the major things we'd like to do, is present an argument that you're in a very hyper specialized area of endeavor. And again, it all depends on your achievements and skills and talents, and what is necessary in order to really place you at the highest level of the particular area of endeavor.
That's beautiful. And what comes to mind, Attorney Sharif, is you're not just an attorney, you're actually like sculpting out, right? When you narrow, you sculpt out, a very clear picture that hopefully the USCIS will appreciate, right? And approve for our clients.
Absolutely.
And then Attorney Sharif, many of our clients are saying hi. Mr. Kanan just got his approval in the consulate, so thank you so much for that, Attorney Sharif. So again, some of our friends are asking about you mentioned about May 15, like if they on board on May 15, we can.
Yeah. So my commitment is those. Again, we have to make that determination based on a consultation and a review, and obviously we're only going to be taking a specific number of cases that are meet our sort of needs and what we're able to do. But for the most part, what we have committed to is those who are able to come on board with us prior to May 15th. We will make sure that their cases are submitted before the end of the calendar year.
Okay, so like we have two individuals waiting after this, but not before you talk about the priority dates, if that's okay. So some of our clients
sure, I can do that. Absolutely. So looking at the visa bulletin here, I'll pull it up if our lovely, oh, there we go. Okay, thank you. So we have our adjustment of status filing charts, the visa bulletin document here. And this might look unfamiliar to a lot of people because what they're used to seeing is this right here, which is the visa bulletin for May 2024. So that's the latest bulletin that's been released. Now, the reason why I look at the adjustment of status filing chart first is because for those of you who are already in the United States, you're not interested in applying for a visa abroad. What you're interested in is adjusting status, is going from a, for example, work employment-based visa to a green card while in the US. So for those people, what you need is an adjustment of status. You don't need a visa necessarily, right? So adjustment of status really depends on, what the dates in the filing chart say. So for example, here it says USCIS determines that applicants for such visas will state on this page may use dates of filing chart, or they may use final action date. So how do we know what date to use? Because if we go to the visa bulletin, there's two dates listed. One is the filing date and the other is the final action date. For those of you who are in the US, it does not mean that you have to always wait for final action date. That's a misperception. People think, oh, okay, the filing date is current, so I can file for adjustment of status, but I won't get my green card until the final action date is current. That's not the case. The way it works is based on the demand. There are times where USCIS will allow you to file for a green card or file for adjustment of status based on the filing date, or they'll say, you know what, we have too many application, it's going a little bit crazy, we're not going to use filing date, we're going to use final action date. So do not send your adjustment of status until we have final action date current. All right, so that's how it works. And every month it could be different. So for example, this month, meaning April, it says for employment-based preference filing, all employment preference category must use final action date.
Okay.
For family-based, it says all must use date of filing. See how confusing it could be? And then it says here for May, data, again, family-based, data filing, employment-based, final action date. And using final action date, I would predict will remain, we'll be bound by final action date for adjustment of status until September. And then starting October, it'll be more current again. Just so you could see my point here, if I go to, for example, October of 23, right? If I go to October of 23 for the adjustment of status dates, it's actually listing it here, but this date corresponded to the filing date.
Okay.
That was so earlier in the year they were using filing date. Now what they're saying is we want you to use final action date. So for May 2024 adjustment of status, your employment-based adjustment of status is going to be based on the not the filing date, which is April for India, April 1st, 21 for EB1A, and then EB2, all countries, is February 15, 23. This is not the date that we're going to use for adjustment of status. For adjustment of status, we need to use the final action date, right? So final action date is right here, final action date. So for India is March 1st, 21.
21, okay.
For first category, and January 15, 23 for all countries, second category.
For
right?
NIW, okay.
For NIW, exactly.
Okay, and then Sharif, just to clarify, filing date is the date when they received your application, right?
Filing date would be the date that you could submit a visa application if you are outside of the US.
Okay.
If you are inside of the US, as of May 2024 and as of April 2024, we are going to only use final action date to even file your adjustment of status.
Okay.
So it's very confusing because the name says filing date, but they're just picking. There's two dates. One is more current and one is older. USCIS is saying if you're going to file your adjustment of status, it needs to be based on the final action date. Do not file it according to the filing date, which doesn't make sense, but that's the government for you.
Yeah, but it does, change every month. That's why it's good to always, consult with Attorney Sharif and maybe, stay tuned and like our channel and follow it, right?
Absolutely. So, it is somewhat confusing, but it's just, we have to just pay attention here and make sure that you understand. Long story short, if you're going to file adjustment of status in the next 8 days or in the month of May, you're looking at final action date. You're not looking at filing date. All right.
Action date. Okay, so thank you
Good.
very much, Sharif, for all these insightful information. And to everybody who's watching us, we encourage you to take matters into your own hands, and it's very easy to consult with us. All you have to do is to log in or follow us on Facebook, and of course, go to www.silmilaw.com. And I think, we're showing that on the screen as well. Anything else
Absolutely.
you'd like to add, Sharif?
No, thank you so much. I appreciate it. And I hope everybody's doing well, and we'll be back soon.
Thank you. We'll see you in our next immigration conversation.